Alright, this is the March 31st hearing. It's where they gave me a hard time about posting my videos to YouTube. State, good morning. Judge, good morning. So as always, no recording, no video on this courtroom is prohibited by the Supreme Court. Just reminding everybody of that. We can proceed. Today is set for motion in limine to preclude publication of witness video and audio statements and production of in-camera inspection. This has been filed by the state. Mr. Hines has filed two motions. One, a defendant's motion to quash the city of Natchitoches' motion in limine to preclude publication of witness video and audio statements and for publication and a camera inspection, and further a motion to suppress witness statements instead of suppression hearing. I believe those two are related, but regardless. At the very least, we should take up the two motions in limine, or the motion for and motion against. And as I believe this was filed over a weekend, I'm going to set the motion to suppress witness statements for Wednesday at 3:30. I don't think there is a time spot, so we'll go ahead and set that one for Wednesday. That will allow Mr. Benjamin to take a look at that prior to Wednesday, and we can have that prior to the hearing. So what we have today is this motion in limine to preclude publication of witness. This is your motion, Mr. Benjamin. Good morning, Your Honor. May it please the court, Cloyd Benjamin on behalf of the state of Louisiana, on behalf of the city of Natchitoches. Your Honor, we filed this motion in limine to preclude publication of witness video and audio statements and for production in camera. Essentially what we're asking is that this court, there is a video of a witness testimony, or of the witness, what the witness said. The defendant already has a copy of the statement, that this was just the video version of it. And we filed that because what we know from experience is that Ms. Travis Hines is going to publish that information. We don't have to guess about that. We know from experience because he's done that. In fact, he filed something over the weekend that says they want Travis Hines to stop being Travis Hines. Travis Hines is going to be Travis Hines. And I believe Travis Hines, that he is going to be Travis Hines, that he's going to do whatever the heck he wants to do in terms of publication, because he's shown that he will. The last hearing that we had, the last hearing after the hearing, I'd like to introduce to the court Exhibit A, which is the printed publication of the witness, who I shall call R. LaCour, of her criminal history. Now, this criminal history is a property of the state of Louisiana, and first of all, law enforcement and the district attorney's office or anyone else is not free to publish this. It's confidential information. It's never supposed to be published. It's only disseminated throughout discovery so that the other side understands what's going on and has information. It's never been published. I'd like to present to the court Exhibit A, which is the publication of this that we received from the internet of that witness's information. Show Mr. Hines first. I'd like to object to that. Okay, based on it's somebody else's website, and I think it's irrelevant. Okay, whose website is this? It says on the bottom, sir. Is that Vince McCucumber? Yes, sir. I've never met that person. I don't know who they are. It's not me. Okay, it mentions your name in here. It says new evidence in Travis Hines' Natchitoches, Louisiana arrest. And also it's out of there. No one would be able to go to her house. There's no address. Nobody would be able to call her. There's no phone number. There's no picture. There's no identifying information whatsoever. I don't even remember what she looks like. I have to get reminded through this new video evidence. And you understand what they're asking for. What the state's asking for is to provide it to you, but not to let you take it with you. But that's what they're asking for. They're asking for you to be able to, in camera, means that you would be able to inspect it sitting in your chair at this screen, to be able to look at it and review whatever video information they have They have an obligation to provide that to you. My question is how? And so they're suggesting that whether you or somebody who is acting on your behalf or in some conjunction has published private information of one of the witnesses on YouTube. I mean, this is clearly, it doesn't say your site, it says his site, but it certainly mentions your name. It isn't something that's not unrelated to your case, but you don't know this individual. So he responds in comments every so often. I'll engage with him in comments. Okay, I don't know who he is, and have you discussed this case at all with him, engaging in comments about this case? Yes, sir. Okay, well then that would seem to me that you know he has some interest in this case. Yes, sir. Whatever it may be, and that would be the concern the state has, is that someone who is willing to publish her information, her criminal record, whether working with you or thinking he's working on your behalf, is releasing information about a witness. I mean, you realize that it's got her height, it's got her weight, it's got her, well, it doesn't have her birthday, thank goodness, but it has information, personal information about her, which I don't think just anybody can get. Obviously he has somebody who works with the police department, because this seems to be public records. But my question is, you understand what they're saying and their concerns? Yes, sir. And as soon as I found out about this, I took down whatever I had that was closely relatable to the allegations and the exhibits. And he reached out to me and I said, yes, go ahead and take it down. Okay, I mean, but you do realize, to remedy that, once something's up, it doesn't go away. So your objection to this is what, to this exhibit? That it's irrelevant now because it's no longer an issue. Well, it is. That's not an objection. I mean, that's an objection, but I'm going to overrule that objection because it's relevant in that it matters for this particular hearing. It doesn't matter for your trial. The question in this hearing is whether or not he hands you this, or whether he asks you to view them in the courtroom. Now, I'm not going to sit here and watch you watch it. You can watch them at your leisure. But what I'm saying, that's what he's asking for. So your objection is overruled for this particular evidence. And remember, this does not go to any sort of weight of your hearing. This is strictly for the basis of this particular hearing. Oh, he's seen it. Yes, sir, I have copies. You can offer and introduce Exhibit A, I think it is. A, Your Honor, A-OK. Your Honor, additionally, Travis Hines has caused a video to be entered onto a website, onto YouTube, which shows the entire library, and the bed of that particular video is the entirety of the 9/11 call from the witness. So he's trying his case to the media by putting that video out there with the underbed of the 9/11 call. The 9/11 call, which discloses the name of the witnesses, what she's calling about, and discloses all that information, which ordinarily would not be releasable by anyone. Exhibit B is the screenshots of that particular piece of information, which we can electronically as well provide to this court to take into consideration in listening to it. And I'd like to offer that as Exhibit B. And all I'll say as a caveat, maybe Travis Hines operates under the assumption that he can procure others to do what he himself cannot or should not do. Maybe he has a misunderstanding of what the law says about that. I'd like to invoke, as I did in this particular filing, LARS 14129.1, which is witness intimidation, and it's a felony in Louisiana. To intimidate, impede, injure a witness or officers is a felony punishable by up to $5,000 fine and 5 years in prison. We would submit that he is very close, if not has exceeded the scope with respect to what is prima facie for witness intimidation. He's certainly there. The last piece of information that we discussed under Exhibit A, which I did not indicate, there were a number of comments with respect to the weight of the witness. etc., and what she has been eating, maybe which was directly related to her personal information being attached to that criminal history. There was no way he could receive this other than from us, other than what was in discovery. And there was no way someone in Pennsylvania or wherever would have received that information. So I'll just be clear about that. It's not in such a domain that even I can go out as an officer in the district attorney's office to just go willy-nilly get this. It is absolutely tracked when I get that information and by whom procures it. I will go so far as to say that I personally, as first assistant, I do not have the ability to myself go out and get a criminal history. It has to be run by someone who is particularly certified. There's one person in our office certified to do that. So this is tightly controlled, but it couldn't just be that someone gave it to him. That came from this discovery. We'd like to offer this as just Exhibit B. This document, I'd like to object as public information. I have a First Amendment right to share it with the people, legal analysts who help me. Well, here's the thing. I'm not going to view the video since I have not viewed any videos on this. So I'm not going to view this video. I'm not going to impair myself for your trial. Otherwise, I would normally ask to see the whole video. I guess my question is, do you know what video he's talking about? Yes, sir, and I did take that down. At any point, well, I guess at any point, is this librarian mentioned or her name mentioned, or his name mentioned, or any of that in this tape or this video? I'm not sure. Okay. It's in the 911 call. It's the 911 call by the librarian. I guess, is there any point? Yes, she identifies herself. Okay, is that right? I mean, I got the video entirely in full without any redactions. Well, they're not supposed to. They're supposed to give you the entire information. The question is whether or not other people besides you, and if you've got followers, even if you have 2 followers on YouTube, that's a lot of people who now have her personal information. So that's my concern here, is what he's asking for, even though you've taken this video down. I'm assuming you said you have. Yes. And I'm not going to watch it. I'm just saying the concern here is people still have, just like you have rights, they have rights too. Like rights to privacy. And certainly witnesses who are being exposed to public. Let's see, this has 17,000 views, so that means 17,000 or 17 people have viewed this video who are not you, and they weren't intended for the other 17,000. They were only intended for you when they provided you information. You understand that? Yes, sir. It is not for public consumption just because you feel like sharing it. That's not appropriate, because this is a trial for you. And when they give you discovery, they're giving it to you, not to the world. Otherwise, they put in the paper, and they don't do that. So this information has to be limited to you. That's the problem that you're not understanding here. What he's giving you is important, and I'm insisting that he give you everything in his file. And today he's coming to court telling me that he has 2 more videos to give you. Now my concern is, it's late. Your trial's on Wednesday, and there may not be enough time for you to prepare adequately. You may have to ask for continuance. That's up to you, but my concern is I want him to give you everything he has in his file. He's obligated to, right? Yes, sir. Okay, but you're obligated not to share that with the world. And that's happened, right? I mean, that's happened in this video, that's happened in whatever that other, somehow someone has her information to look through a criminal search for her. That's my concern. Yes, sir. And I have a lot of support on this channel in the form of legal help. It's a channel that's very narrow, and it's a niche market, so I have a lot of response with, they think they notice things. They think of things that I don't think of, and it's very helpful to me. But that's not appropriate, because you let in anybody You open the door, everybody comes in, whether they're legal helpers or not. And by sharing that information, you don't know who you are sharing it with. You didn't even know who Mr. McCucumber was, right? Mr. Cucumber? Those are legal issues, is a combative form of learning, sir. It's not learning science where people cooperate towards a positive goal. In the legal realm, people are combative and argue, and they learn that from the beginning all the way through. And we have these types of discussions talking about the legal issues for each piece of evidence, each statement made. And see, the problem is that's not the other people's business. Their information is not other people's business. If you had any kind of violent crime trial, you wouldn't want the victim's name being out in the public so she could be harassed, and it may not be by you. It could be by someone who thinks they're doing good on your behalf, right? Yes, sir, and once again, and you said you can't have no control over them, right? You don't, that's what your motion said. You have no control over people who are out there, and you're not responsible for them. Yes, sir, there's control over, there's no date of birth, there's no picture of her. It's her name. Yes, sir, there is. Why would you want to share someone's name with people? She's a public worker she's an employee of a library. That doesn't mean that she is a government official. She didn't run for office. I ran for office. You can ask me anything you want to ask me. You can question me anytime you want to. I work for the government. She is an employee at a library. My concern is there is no legal boundary that helps you by people knowing her name. Is there? No, sir, you are right, yes. I mean, her name, she could be Jane Doe, and you could have shared legal theories with all of your followers, but giving her name out there doesn't help anybody except for one bad thing, right? Yes, sir, it's my mistake. I'd like to put out a lot of detail in my case. But again, I'm going to admit Exhibit B, but you know my concern here, again, is what I want you to have the information, but what's happening with it isn't good. I mean, it isn't. Obviously, you have to try your case. You have to be prepared. But witnesses don't have to be harassed. They don't have to be intimidated. I mean, have you identified yourself as a witness intimidator on social media? On my channel, there's serious topics, but I try to relieve the pressure of some of the serious arguments by using satire and sarcasm. Not everyone gets it. Yes, that's true. Not sarcasm sometimes goes over people's heads. Yes, sir. So not everyone gets satire and sarcasm, so it's a concern. But anyway, I'm talking and listening to both y'all argue on this point. What else do you have, Mr. Benjamin, that you want to argue? Exhibits C and D, and I want to talk about these separately. C does the same thing with respect to followers making disparaging comments relative to the librarian, who is a private individual, who is a witness, making disparaging comments about her, including personal business such as weight, etc. And that's Exhibit C, which is harassment and intimidating. And I might add, where did this come from? Where is this? This came from YouTube, as well from his YouTube channel after he published information out there. But for his publication of information, we wouldn't be talking about this. Right. We really wouldn't be talking about it. I will say this as a caveat to this judge, that I'm so concerned because the witness feels intimidated and is afraid. These witnesses are afraid for their safety. We have serious concerns that this might be something that the detectives get involved in to determine whether or not any laws have been breached. Not for this court, but for district court, for felony charges or on witness intimidation. And that's not today, before the courts today, Mr. Hines. Yes, sir. But what he's saying is they may address it. They can do that if they'd like. It wouldn't be in front of this court anyway. it's a felony. But you know, we're not hearing any of that today. In case you're concerned that this is somehow a hearing on witness to intimidation, it's not. It's strictly a hearing to try to determine whether or not or how to get this information. Anyway, so you want to show Mr. Hines both C and D. So these are on what YouTube channel? Are they on Mr. Travis Hines? Oh, they're on yours? Are you familiar with these, Mr. Hines? Yes, sir. I did see the pieces of evidence. Your Honor, there's an additional, this would be E, and this came to my attention this weekend. This was a little disturbing. This came from the defendant's YouTube channel, and this is in relation to this particular hearing, which also means that we know that this particular hearing was set, I believe, on a Thursday. So this is information he would have put out since Thursday regarding this particular hearing, at which time he showed the information of what this particular hearing was going to be about, witness testimony and a video. And the responses on that is, for instance, looks like they only want to give you some witness video. What is the emergency? Okay. Okay. Depositions are sworn testimony, so if your video shows different from what they say, it's perjury. Cops are clowns. I love calling and cussing them out. I don't make threats. That's from one of the followers. I killed the Illuminati. You should have did what I did. Look up, man, his way to victory and get your case dismissed. These are disturbing comments. And again, the premise is that we would offer this as D, but the premise is E. The premise is that the defendant obviously thinks he can out intellectually smart everybody by putting stuff out there that we have never had this happen before. Putting things out there because it's given to you, and then saying, well, I don't know what happened. I didn't do anything with this, and all of these people can come back and do what any other witness would be. I promise to you, if this were a felony case and he had made comments like this, there would be another case open against him for witness intimidation. You just can't do that. A witness is not a party. They're a witness, and you can't harass them and intimidate them. Not only this addresses what they're talking about. You know, I have real concerns about who is the Illuminati. Is that the person in power? I kind of want to know what that means, because I kind of feel some kind of way about it. Are you familiar with this document or these statements that he's making? No, sir, I am not. Okay, where are these at? On his YouTube channel. These are on Mr. Hines' channel? Yes, sir. Okay, are you familiar with that? No, sir. This looks like it's about the chats, the chat log for a live stream, so it moves fast as the comments go. I don't see any comments from me. I object to it. Okay. I didn't make any of these comments. Cops are clowns. Looks like it's the actual name of the person, not a statement. Also, I would like to add, can I see the document now that you've objected to it? And Judge, okay. And Judge, again, this is part and parcel with the problem that I think we're having. Apparently, the defendant believes that I can push anything out there and anybody can say anything about it. They can harass people, they can pick up the phone, they can make admissions that they're calling around town, calling everybody everything but a child of God. And I could just hold my hands up and say, well, I don't know what this is about. I had nothing to do with it. I just don't know what happened. I didn't say that. They have a right to say what they're saying. Everything leads back to him and only exists substantively because he put the information out there on his proclaimed channel, not someone else's. It's something he has immediate control, access, and purview of. He has ownership of that particular handle in that particular corner of the electronic internet market. That is his. It is his domain, and what he puts on it is his. What he puts on it, he can either allow it or disallow it. He allows it, he invites it, but for him, we would not be here. And I really don't think he understands that just because someone else, piggybacks on what he puts out there on his channel, that he can say, well, I'm not responsible for it. So it just kind of goes away. I'm probably being recorded is why I'm saying all of this. Well, no, you wouldn't be except for the transcript, because we already have that order in place, so I'm sure you're not being recorded except by the court reporter. Yes, sir. Alright, well, I'm going to offer, I accept this for what it is, which you've identified as a stream of comments. You have not made any of the comments on here, Mr. Hines, but this is on your channel. But anyway, I'll accept the stream as Exhibit E for what it's worth. You want to argue, sir? Yes, sir, I'd like to. And Judge, one last thing, if he's argued for that, he has argued against that? Yes. Okay, one last part that we'd like to address. What are the solutions? We believe that what could be done is that we could make available the video. Now, I'd like to say the video contains nothing new. There's absolutely nothing new in the video. It is just a picture recordation of what he already knows that was already received by him. That just happens to be a video. I want to make it available to him, but for him to view it in a controlled environment where the marshals or someone are looking to make sure he's not recording it, and he can take notes or do whatever he wants to it. Essentially, he has the information already, but he has an objection to obligation to see it. Again, there has been no new facts that are in it, but to have given it to him last week, or to have given it to him, cringed me, because I knew as soon as that happened, it was going to be posted, and there would be a face to this lady and to these persons who are witnesses. It just would have gone downhill. I just knew this in my heart. Not because I don't trust the defendant, because time and again he's done this. He's done it, so he has a track record. So it's not about him personally. It's about his actions. And nobody wants to be on there. Nobody wants to be on his video just because they're doing their job. That librarian and the librarians have a right not to be on video because they just went to work and have to testify. So we would submit that it be done in a controlled environment. He can look at it and he can go about it his way, but to give it to him on a USB is to post it all over the internet. And we would just submit that we'd just like to produce it to him like that. And he can look at it. It's only a few minutes long. He can look at it. Is it one video or is it two videos? It is actually two videos. Okay, two different people look at for whatever. I think they're not more than 10 minutes long. And look at it and take whatever time he'd like to, like in a controlled environment with some supervision, and take his notes or whatever, and we come in here and do our trial on Wednesday. Mr. Hines, thank you. Your argument? Yes, sir. In my defense about the comments on YouTube, I'd like to add that YouTube has their own policing, their own legal team and analysts, and that then there is a community that reports. There is a reporting system on YouTube about sensitive information. People's videos and entire channels have been taken down on YouTube. It doesn't rest on the city to have to police this website and every library I've been in across the whole west half of the country in my travels, YouTube has never been blocked. It's a trusted website, it's policed, so may have my own domain in YouTube, but it is policed heavily, and it's a strong first step towards preventing problems from developing. It hasn't so far in this case. I mean, sensitive information, in my opinion, has already been released on YouTube. So they may prevent crimes, and these weren't crimes necessarily, but my concern is just the documentation we've talked about today, is stuff that should have gotten out on YouTube. So I'm not faulting YouTube, that's fine. They have their own, and remember, they're dealing with not a Louisiana law, they're dealing with a national law. But either way, that's their issue. My issue is protecting what's in this court, and what I want to do is I want to protect evidence that I think is germane to this case, which means witnesses, which means identification, all of those kinds of things. So I'd rather this stay within the confines of this room rather than it going to on the internet. So that's my concern. Yes, sir. So your argument in your motion you filed a responsive motion, you filed a motion to quash. Tell me what you want to about that. Yes, sir. I have added statements that didn't quash, that didn't cover, that I'd like to read to the court. The city prosecutor is untruthful. The city argues defendant's videos posted on his social media account typically conjure an average of 10,000 harassing, intimidating, and violently belligerent comments. Well, as of 11:20 to 11:12 a.m. on Sunday, March 20th, these are the counts for the most recent 20 videos on my channel. 414, 572, 143, 641. I won't read them all, but they average to 354 comments. So a minimum of 116, max of 739, sum total of 7,070. And I respond a lot. So a lot of those comments are added, they count me too. In response to these 20 journalistic free press publications for Mr. Hines, the average of 354 comments does not approach the 10,000 average Mr. Benjamin cites to this honorable court. Mr. Benjamin's brazen misrepresentation to this court is not his first, and we expect it will not be his last. On these grounds, and to the interest of justice, I request immediate dismissal. Well, that's another step. We're talking about whether or not we bring this action. I'm not dismissing anything today, but what I will tell you is, you're right, he did mention 10,000 and you're saying it's 716 or something like that. That's good. I'm glad it's not going out to more people. But it doesn't take more than one person to do something inappropriate or to harass. All it takes is 5 people to call all day and or to harass people at their homes and businesses. So I'm glad that it's not 10,000, but that doesn't make me feel any better that there's still clearly people who are making comments directed towards individuals that are nothing more than witnesses in this situation. They're not police officers, they're not members of this court, they're witnesses, and I am not going to have a hearing on witness intimidation today. Clearly, that's, if the state decides to bring that, they can bring that. That's another whole action. And you have appropriate time to have a representative or defend yourself on it. That's not an issue here today, but what is an issue is your right to these videos. My concern is the timeliness of it. I'm a little disappointed in the state that it is this late, but at the same time I want you the opportunity to view them. They're probably the same thing as the written statements you already have, but that doesn't matter. You have a right to view them, but I'm uncomfortable with them going up on the internet. So what I'm going to ask you is to do what they have suggested, which is to take your time and to review them in camera, which means that you can look at them. And I'm going to suggest a small courtroom because we have another hearing at 9. You can go in the small courtroom and hopefully they can play on that system. Is that likely? He should be able to. Okay, so hopefully we can play them on that, and you can, with a marshal, not record these. I'm ordering you, again, not to record these off of the video that you're seeing. You can watch them more than once if you want to take notes. The other thing is, I don't want you to feel that we're rushing this trial. As I told you when we set this date, we can do it in May, we can do it in April, we can do it in June. I'm going to be here all 3 of those months and months thereafter. So I want you to have the opportunity to properly be prepared for your trial. So I don't want this to be considered an ambush or anything like that. And in fact, it's actually moving along much faster than most trials. So if you'd like, after reviewing them, or right now, you can tell me if you want a continuance. If you want a continuance, I will grant it over any objections that may be from the state, because I think you have the right to prepare for your trial. So you tell me what you want to do, and otherwise your other motions I will set for the other motions we have set on Wednesday. There's a chance that after hearing that, I believe now the civil firm of Gold and Weems is involved in discussing your request for the police department, you may want to have the motions that day. You tell me what your position is. Yes, sir. It would be prejudice for my case if this were to go to trial on Wednesday, so I would ask for a continuance. And I'll grant it. Let's pick a date. I want to pick a date that everyone is available. That way you have time to prepare, time to have adequate, it is 2 days from now. Now I'm going to leave the hearings that we have set on Wednesday because we still have your motion hearings set that day, and Gold Weems will be here to argue that. I don't know who is going to be here, Mr. Oxenhandler or whoever, but we'll handle that day, and then but we should pick dates now for trial. And again, I'd like to set a separate date so that we don't have this conflicting with everything else we have set. Tell me how long you need to prepare. Me, 10 days. The minimum standard, as far as I understand. It's however long you want it to be, actually. However long you want it to be. Alright, so that would put us into what we look like. Week of the 11th. What do y'all have, Mr. Benjamin? I think Monday the 11th would be available. I'd be available. I think later that week there would be other appearances. So what about the 13th? Is that possible? No, the rest of the week I'm unavailable. However, I could be on the Monday. Well, I don't mind doing it. It will be out of town on the 7th and 8th. And my problem is motions have a tendency to get filed the day before here. So I don't want to. We don't plan to file anything else. Okay. We really want to give Mr. Hines and look with all due respect to Mr. Hines, we want to give him his opportunity in court, an opportunity to be heard, and let the ball fall where it may. But we honestly want to judiciously get it done so that we can have this matter behind us, and so that he can have it behind us, and hopefully other people that happen to be collateral damage can have it behind them as well. Well, then we're going to set it for the 11th, if that's okay with you. Yes, sir. That's the soonest we can get it set, and that will allow us at least, and you, plenty of time to get it done. Again, I will be out of office, but in contact with the office on the 7th and 8th. But again, if anything gets filed, I'll certainly address it by email. But I will not be in town, but we can hear it on the 11th. That gives you plenty of time, hopefully, to prepare. Is there anything else we need? And what time would we do that hearing, Judge? 9 o'clock. Yeah, start right at the... Thank you. And I'm hopeful that we have nothing else to file with respect to any other leaks. So you understand, you have the information with you, Mr. Benjamin, the witness information? Yes, sir, I do. Okay, so I'm going to grant their motion insofar as you have the right to inspect these and you can have an in-camera inspection. I'm going to deny your motion to quash this particular motion, but your motion to suppress witness statements we're going to set that you filed over the weekend. I'm going to set that for Wednesday the 23rd, as well as the previous motions we have set for that day. And is he going to provide, as customarily, are you going to provide a copy of that to us? A copy? I emailed copies. We just got them. They were emailed on Saturday, but obviously we did not work until Monday morning. So we have them, so you'll have a copy of those. Thank you. So I'm going to sign it today and set it for Wednesday the 23rd. Excuse me, Your Honor, I have a question. Shoot. Is it verbatim of their statements? I have no idea. I haven't seen it. You'll have to watch it and see. Oh, okay, because I have their statements, so I would compare. It doesn't really matter, the comparison of it. Judge will submit that's a trial issue. That's not an issue to be in motion in practice. Right. If there's something different on what they say, or more expansive on video, which there likely is, because people tend to say more as they speak as opposed to what they write. That's a trial issue. Yeah, you could argue that. That's not an issue for a motion. Absolutely. If you feel that somehow the information's off, but I mean, you'll have their information by video, you'll have that statement, you'll have that transcript, so you can argue if you feel that somehow you've been misled. But I mean, you're going to, the other thing is this, I'm assuming those people will come into court, so you have the opportunity to cross and examine them. Is there an additional one of those comprising of a librarian that I was not familiar with, that the police department indicated to me was spoken to, and they did a recordation of a video. I don't think there is a written statement from that person, so that's what you have. And again, that's a trial issue, so it is in terms of what it is, and that's a trial issue. I'm going to need verbatim everything that was said in the videos at least. So that's what you have. You'll have the video. Yeah, I know. You'll get to look at it. I mean, that's what the purpose of looking at the video is. You'll have the opportunity. Judge, I'm concerned not to beat a dead horse, and then I'm going to shut up. He can watch it. As the court indicated, he can take verbatim notes. Yes. I'm concerned that when he uses the word I need verbatim, that means, to me, that translates into recordation. It has in the past. No, you're not going to be allowed to record their statements. That's the whole purpose of not putting it on the internet. Otherwise, have said he could hand you the videos and then you'd put them on the internet. Yes, sir. So, no, I'm not going to allow that, but I'm not allowing you the access. So I'm not going to allow that. I'm allowing you the access to all the information that's in it that you can sit and watch. You have a transcript of them. If you do have a transcript, you can go by the transcript and watch the video. And if he said instead of you can put that in there. But I mean, you're welcome to look at the videos. I mean, there is no hiding the ball. That's what I'm asking him not to do here. The only difference is you're not allowed to take this material with you for fear of exposing these individuals to more or any harassments. I say more because I think what's already gone on has been harassments, but it's not. I'm saying I'm certainly saying individuals have, and whether they were doing it to help you, or because they just felt like doing it, whatever happens, all that's inappropriate. Putting someone's criminal history is inappropriate on the internet. There's no identification that anybody could go to their house, call them, identify. It's her name. Yes, sir. No one know her name. I don't know her name. Before I saw that document, I did not know who this individual's name was. I don't think it was in the police report, the affidavit I signed. So that's her name. That's a lot. And I would argue that I was embarrassed by the newspaper. My name and picture was put on their websites. But you were arrested. That's a different story. Okay? She wasn't arrested for anything. She's a witness to a crime. Whether you're found guilty is up to the states, up to the evidence, a trial. But the problem is, once you were arrested, you're fair game, unfortunately. Now you're not considered guilty. You're just arrested. That's it. But that's where we are right now. You will have a trial. You were arrested, and that becomes public information. Someone who is working as a librarian and is a witness has a right to her privacy and not a right to be published. Do you think that's okay to put her name out there? Sir, it's her name. There's nothing else. But why would that be okay to put out there on the internet? A name doesn't lead to anybody to her house. Really, you can't look up someone on the internet. I can't go try to find her right now on this phone and I can't find her. You think I can't? That would be her choice to publish her information on the internet if she so chooses. And Judge, we would submit on that. I mean, it doesn't take rocket scientists to figure out the director of the library is at probably at least 8 hours out of the day at the library. That's common sense. He knows this. But either way, my concern is just, it shouldn't be out there whether it's just a name to you. Her name shouldn't be out there. She's not a public official. She's an employee at a library and a witness to a criminal proceeding. That's it. That's it. It shouldn't be out there. If she ran for office, sure, then you waive all your rights. You're running for office, and Mr. Williams knows that. You run for office, you're out there. Mr. Williams? And Judge, we're more concerned, and this is just in response, we're more concerned not so much about her name, we're more concerned, and we're going, may look into the ramifications as to whether or not this was any felonies implicated by the release of this that is strictly prohibited under the Louisiana law. The whole document itself, I don't care whose name is on it, that's the issue. There's writing at the bottom that says it's not supposed to be released, and there are legal consequences for that. And the other thing we're concerned about is whether or not the continued comments relative to this witness under LARS 14129.1 are a violation of the witness intimidation statute, which is a felony. That's what we're more concerned about. That's not before this court, and it won't be before this court. This court is not involved in that. Yes, sir. So we are set. We will hear the motions on Wednesday. You can now proceed. Hopefully we can set that up. You have the information to go to the small courtroom and be able to view the videos, and I would ask that a representative of the marshal's office accompany him, and then Wednesday after we hear our motions, we'll make sure that the date is still good. If there is a need for a further continuance, you can ask for it. I want you to have plenty of time to prepare for this. So we're set for the 11th for a trial date at 9 and Wednesday for motions. Does that go in there? Yeah, it can go in there because he knows that he's under order not to record it, which I'll make clear. You're under order not to record any of that video you see. Court adjourns.